The judge still has not made her ruling. So I thought today, in between some other things obligations that I had, that I take a look and try to think about, what's been said in these filings. What might, be the delay? I don't know. I have to stress that. I simply don't know how the ruling is going to come down because service and personal jurisdiction is a very important threshold. That's what I'll say. Threshold that has to be met. I don't know all of the laws. I'm here in Michigan, and the defendant says that the court doesn't have jurisdiction and that they weren't properly served. More specifically, or I'll just say it like this. Danielle's latest filing, the 71, is a perfect example of that to me. Okay? I'm going to give just a little commentary, my impression, my analysis, my thoughts. Fair use commentary. My takeaway is that she's not just stretching the truth, but she's twisting it into, let's just call it a legal pretzel. So she claims that I can't bring forward new evidence after my initial complaint, even though federal courts allow exactly that when providing or proving jurisdiction or service. She also tries to, I'll just say, misuse a Supreme Court case, Calder versus Jones, pretending it doesn't apply when someone targets a Michigan resident for harassment. She argues I didn't serve a legal person when she is the one filing motions and appearing anonymously and actively participating in this case. So tonight, just remember this. D is for distortion too, because when deflection becomes desperation and distortion becomes self-exposure. That's what I'll call it.
So don't you tell me I am selfish just because I look out for myself. I've been happy, working hard, so I won't have to cry when I'm older. I could have done this or that. I remember when I used to. Don't do it cause it doesn't work. I'd rather tell you, shoot your shots. I did it, so I know you got this. We're all living one manifest. You'll get your dreams, just do your best. So don't you tell me I am helpless just because I'm searching for myself. I've been happy, working hard, just so I can say I told you so. I told you so. I don't need your approval to be myself. I got that on myself. Gracefully, gotta keep it cozy. I'ma take it slowly, one step at a time till my time is up. Why you stay mad at me? We gon' make mistakes, we gon' disagree. Are you so proud of me? If you just wait and see, you gon' ride. So don't you tell me I am selfish just because I look out for myself. I've been happy, working hard, so I won't have to cry when I'm older. I could have done this or that. I remember when I used to. Don't do it cause it doesn't work. I'd rather tell you, shoot your shot. I did it, so I know you got this. We're all living for better, best. You'll get your dreams, just do your best. So don't you tell me I am helpless just because I'm searching for myself. I've been high, working hard, just so I can say I told you so. I told you so.
So, again, tonight is DForDistortion 2, because I'm addressing some things that I see in this ECF 71. Or at least I'm giving my impression. I'll just say it like that. Just a few things. Where the defendant argues she can't be sued under her pseudonym, while actively defending herself under that very name. She says service is invalid because she's not a company. She says the name used in court isn't legal. But it's the same name she used in monetized content, copyright claims, cease and desist threats. She says, I knew she was anonymous, yet she's the one showing up in federal court, still anonymous, trying to silence me for calling her out. So, just think about this one point. If you're real enough to sue people, then you're real enough to be sued. If you're real enough to sue people, because she filed a lawsuit and then withdrew it in a federal court in California just recently, using the name Danielle Robertson. So if you're real enough to sue in that name, then you're real enough to be sued. It's my opinion. But we'll have to wait to hear the judge's ruling, right? So just think about that. Jurisdiction is one of the thresholds that must be met. And it is proven by evidence, not just the complaint. So federal courts routinely, my understanding, allow plaintiffs to submit declarations, exhibits, jurisdiction, proven by evidence, and that the courts, my understanding, allow submission of declarations, which I've submitted, exhibits, evidence outside the initial complaint to establish jurisdiction. It's not just the complaint. So when you intentionally target a resident of a state, especially with harassment, online attacks, and reputational harm, then there's case law that applies. And I've cited in my brief several examples of case law. Again, it's going to be up to the judge to, she's the judge and knows the law, the federal laws. But Danielle's own videos show that's exactly what happened. Targeting a resident, the plaintiff, myself, in a state with harassment, specifically targeting to cause harm. Mm-hmm. Yeah. She mentions multiple times contacts with authorities here in Michigan. The list is numerous, it's long. Not to mention the Michigan Medical Board, contact with law enforcement right here in Michigan, then obtaining the cam footage and playing it on her YouTube multiple times to cause harm and harassment. That's just one or two examples. Okay. Also, service. She talks about that. When you put together someone who is a known alias and they're actively participating, it will be up to the judge, but there are laws where it could be waived or a waiver for service. Mm-hmm. You can't claim anonymity while showing up in court and filing motions. And Danielle can't play Jane Doe and Daniel Robertson at the same time and claim to be unserved. This is my words. We'll have to wait for the ruling, but I'm letting you know my thoughts and some of the things or the way I approached it. Okay. I used and I cited law, so I'm not going to, be reading my brief, but I'm just giving you some highlights of her argument and some of the things that I thought about when I looked at this show cause. Also, she has this I'm not a legal person defense. Mm-hmm. Well, if this defendant is signing declarations, making filings, and asking the court for relief, you're a legal party. As a matter of fact, this argument just screams desperation. And anonymity doesn't immunize a person from service. Courts have repeatedly ruled that pseudonyms don't protect you from litigation when you're actively participating or concealing identity in quote unquote bad faith. Again, all of this has to be determined. I don't know how the judge is, you know, going to look at everything and weigh it with everything else that's been filed. Okay. But personal attacks aren't legal arguments. And there's a lot of personal attacks throughout these filings against the plaintiff, myself, by the defendant. I mentioned, like this dragging up Halloween, I'll just say jokes, live streams, personal commentary with a question mark. That's not a jurisdictional defense. That's deflection. There's nothing to do with jurisdiction. She's trying, again, my opinion, to reframe this case with this straw man argument saying, I'm obsessed or fixated, and ignores the legal claims that are on the table: jurisdiction, service, and evidence of harm. There is a clear pattern: dodge, delay, distort. Another attempt to cloud the court's view with noise and not substance. It's like a mix of things. And if she's participating, the judge will make the ruling whether or not she's subject to jurisdiction, because active litigation and or plus direct targeting of a Michigan resident equal minimum contacts. That's what the judge will be looking for in this threshold of jurisdiction. It's called minimum contacts. Mhm. That's the law. That doesn't change. So, again, I don't know everything. And still, I'm just waiting. Because one way or the other, eventually the judge is going to rule. I don't know how it's going to come out, but eventually there will be a ruling. Mhm. Don't know. This seems to be more of, again, it's just my opinion, maybe the way I'm thinking about it because of the length of time. We're going into week 7 tomorrow. No, we will be at the end of week 7 since I filed. So on Thursday, we will be going into, if a ruling doesn't come down tomorrow, into week number 8. Mhm. So I think, and again, it's just my thoughts, the complexity, the opposing arguments, I don't know. Maybe she's looking at, everything from the beginning. I just do not know. Mhm. I don't think it's as simple as it might seem on the surface. Yeah, I don't know. Okay. And it is 11:16. See? Wow, that 25 minutes went quickly. Let me come out and read some of your comments, and then, um, yeah, and then I'll, yeah, definitely wrap it up before or by 11:30. Mm-hmm. Yeah. Um, and I did loop back. I looped back and, you know, right from the beginning when John Doe filed and then subsequently Jane Doe. And just, rereading the responses, rereading my responses. Okay. Because so far, the judge has really made a decision on quashing the subpoena. All right, so that was made for both um, John Doe's request for block and for Jane Doe. Okay, Danielle's request to quash Google. All right. And I did say where John Doe said he sent an email. I saw something in an exhibit to block. And of course, certain things were redacted out. But I don't see where, unless I need to look at maybe other filings, I haven't yet seen where I have looked. In fact, I haven't seen everything, so I'll look again. A receipt or exhibit where Block contacted John Doe, okay, with the receipt. I'm just saying, all right. I see where he reached out to Block, but I don't see the initial date of when they would have contacted him. Okay. I also don't see a date when Google reached out to Danielle. And she said that's when she first learned of this proceeding. I don't see that either. Okay. So, again, there's a threshold. It's service and it's jurisdiction, and both must be met. And I'm just going to say it's probably complex in this case, because if it were a straight, for either side, I think the judge could have ruled by now. Mhm. But again, I don't know. The caseload could be very, very heavy. I simply do not know. Yeah. Okay. Shout out to my moderators, Vicky Black and Baby Juju, all of you who are joining me. All comments and opinions in the chat are allegedly. and they are your own. Mhm. Let's just go here. I'll just start reading some. Polly, good evening, says, oh, yeah, that's taking up taxpayers' dollars of Michigan's workforce. I didn't read before that. So let me go up. Let's make sure. Flying High, Victoria, Angie Green, or is Fly High, sorry. Love Wins, I see you out there. Rye. Sharon Sayers says jurisdiction is complicated. That's what I'm reading. Yes, there have been, a number of cases that, you know, plaintiff argued jurisdiction and was not successful. It's complicated. And add to it, I'm dealing with someone who is anonymous and has used multiple aliases and is moving things, you know, around and is, I've said it, they won't be found. This is a deliberate strategy. However, whatever they're saying in these filings, to make it even more complicated. Mhm. So that again, I don't know, but if the judge doesn't rule in my favor, then she can say, see, hmm as if I did something wrong. You won't be able to say that. No, because if a person isn't providing the information, that's true. I'm going based off of what was given, even to YouTube, to the CB filings. There's just a lot of things. That's was the known address, that registered agent. Okay. It's not that all of these attempts and that I think she has been served. Mhm. The first notification would have come from YouTube and the DMCA. And she thoroughly knows how copyright works because it's in the filings when she contacted. Let's see, there was a video that I included as an exhibit when she called my attorney. Mm-hmm. In that video, the same video, she talks about copyright. She talks about the 10-day waiting period. She talks about a lawsuit having to have been filed, the procedure. So she knows. She knew. This is my absolute belief. Daniel Robertson, the defendant, knew when those videos came down, when YouTube removed those videos, that they would not be restored if a lawsuit was filed after the 10 days, and the 10 days had passed. She knew because YouTube was in touch with her just like YouTube was in touch with me. And YouTube required me to submit evidence of a filing of a lawsuit, which included the summons and complaint that she would have been notified of. Mhm. That's the first time. And I put that in my response. So Daniel Robertson has been served in my belief. She's been properly served, my belief. But it's going to be entirely up to the court. Mm-hmm. That's just one example, and there are others. Mm-hmm. But it has to pass the test, and that's just part of it. Yeah. Okay. So, don't know how she's going to roll. Okay. Who else wants to make a comment, or I will. I'm just looking at the clock. Boy, time flies. Okay. Rice says she believes she's immune to the law. She has said she will never be found. Mm-hmm. And she has said if she thought she was going to be found, that she was going to disappear. And that's not allegedly, but I'll say allegedly. But I have it close by. I have it. You can't see it. You might hear it. I have a thumb drive that has that on it. I bought a new one just for that. And I've made multiple copies. Mm-hmm. Where she said she's, in her own words, in her own voice. Mm-hmm. Yeah. Because she's saying, like, well, you have to prove it, you know, make the plaintiff prove, show evidence and prove things. I hope this case moves forward so that I can get the opportunity, if called into question, anything, to even have a hearing with the judge. Mm-hmm. Yeah. And what Danielle's banking on is, she's asking for the case to be dismissed. Mm-hmm. Yeah. Don't know. Polly says, I would pay to see the judge's first reaction to them seeing all the evidence. I wonder what she's, obviously looking for things that will be within the law, yeah. Because she asked the plaintiff, me, to show cause, not Danielle. Although Danielle responded right after I responded to the judge to show cause. She decided that she would follow up with a supplement. And I can't respond until resolution of service and jurisdiction that has to be resolved before any, you know, before that would be lifted if this case is going to move forward. So I can't even respond to the court. Yeah. And there is a lot to respond to, but I have to wait. Yes, listen carefully. You're cooking. Huh, okay. Dinner, it's all right. Wherever you are. Yeah. Oh yes, the judge on the bench, the magistrate, and the district judge. They're they've been on the bench a long time. They're very familiar with you know cases that involve service and jurisdiction. They're federal judges, and they see criminal cases as well. So, in criminal cases, um, way much heavier than civil cases. As far as I think the load. Yeah. You can email me at unwinewithteddy@gmail.com. Yeah. Anything else before I say goodnight? It's 11:43. I've run over. Um, I think we're good. Yeah. All right. That's going to do it for me tonight. I appreciate you hanging out with me and listening. Biggest bear hugs go out to all the grizzlies and the honey bears. Please hit the like on your way out and keep your bear phones on for, my next broadcast. That's it. It's time to say goodnight. Thanks for watching. Until next time, I'm Teddy. Now it's good night.
Another new day. 무신자 햇살 어두운 밤 지나 찬란하게 빛나. I've been feeling down all night. You tell me it's alright. It's alright, alright, alright. So blue. 저 하늘은 더 푸른 바다로. How deep it kill me when you jump up. 힘껏 달려가. And now 두 발을 벌려. Dive into the sunlight. When you're down. Just dive into the sky high. 날아오를 시간. 어디론가 떠나고만 싶을 때도
Not worried about it.
You go.
Not worried. Not worried.
기댈 것이 없다거나 느낄 때도 Baby it's alright. It's alright, alright, alright. So blue. 저 하늘은 더 푸른 바다로. How deep it into the sunlight. When you're down, just dive